أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. Now, in our lesson today, we shall be talking about water law and rights. And this is one of the most important modules in this course. Because remember, this course talks about issues related to water governance and policy. Now, when you're talking about governance and talking about policy, we cannot talk about the two without talking about law. Now, we all know that water is a basic human right. In fact, as per the United Nations, it is a fundamental human right. So today we shall be talking in detail about what is water law and what do we mean by water rights. Now, so these are going to be our lesson objectives today. That is, by the end of this lesson, you should be able to, number one, define water law and explain its role in water governance. Number two, describe the scope and sources of water law. Number three, explain the key principles of water law. Then analyze the concept of water rights, compare major water rights system, differentiate between customary and statutory water law, explain the concept of legal pluralism. Then lastly, discuss cross-cutting principle in water rights system. So in brief, this is what we shall be discussing today. Now, as we start, as we always do, we always start with a question. And the question we are asking today is, who legally owns water? That is, who owns the water we use in our houses, the water we drink, the water we use for our domestic use? So the question is, who owns water? Of course, in the Islamic perspective, it is very clear. It is Allah who owns everything. Now, but just to answer this question on a contemporary context, who legally owns water? So there can be many possible answers to this. So some people might argue that the government is the one that owns water. Some people might argue that it is people who own the water. Some people might argue it is the landowners. People who own the land, they are the ones who do what? They are the ones who dictate and decide how the water is going to be used. So water ownership is complex. It's not an easy thing. It's not a simple thing. It is complex and varies by legal system. And it varies by the legal system a country is applying. So the key message is that water law determines who has rights to use water, under what conditions, and how conflicts are resolved. So this is basically what is meant by what? This is what water law revolves around. That is, who has the right to use water, under what condition. Then lastly, how conflicts are resolved. For example, there is a conflict of the usage of water, the amount of water. So anything, any misunderstanding, any challenge, barrier, problem that results, then the water law needs to be critically applied. Now let us start our lesson. Now, as we start our lesson, we have to define in detail what is water law. Kanun al-Miyah. So water law refers to the body of legal rules, doctrines, and institutional frameworks that govern how water resources are owned, assessed, allocated, managed, and protected within a given jurisdiction. So there are important things in this definition. So number one, water law refers to the body of legal rules. So when you are talking about body of legal rules, these are written laws in a country, or sometimes they can be doctrines in form of constitution and institutional framework. Institutional framework means the institution. Remember in our last lesson, we were talking about institutions. So this institutional framework, every country, they have institutions that govern the usage of water. So that govern how water resources are owned. So these laws, these doctrines determine who has the right to own water, how can it be assessed, and if issues of allocated arise, how can water be allocated, managed, how can water be managed, and protected within a given jurisdiction. Jurisdiction means with borders. So like Somali it is a jurisdiction. Kenya is a jurisdiction. Uganda is a jurisdiction. So every country has a law that governs the borders. Those who are living in Somaliland, they are subjected to those laws. So more comprehensively, water law, number one, defines who has the right to use water. Number two, it establishes state authority versus private or communal rights over water resources. It establishes the state authority. So one side, we have the government. The other side, we have the private sector and we have the community. So it establishes the authority. It establishes the boundary. The government can do this 1, 2, 3, and 4. The private sector, these are their boundaries. Then number two, regulates competing demands. So the water law, actually, because in any country, every sector, they have their demand. So it decides what percentage of water is going to agriculture, what percentage is going for domestic use, and the industry, and the other ecosystem. Then lastly, provides mechanism. So the water law also establishes mechanism for what? Sustainability. And remember, we've been talking about this sustainability. Sustainability means the what? We are using the water effectively and efficiently, so that our generation, they can get water, and the future generation, they can get water. So there needs to be a law for that. Equity. In our last lesson, we discussed about equity. And when you're talking about equity, is that all the regions, they get and they can easily access water. And conflict resolution. So in a nutshell, they're telling us in modern governance, water law is increasingly seen not just as a regulatory tool, but as a framework for balancing economic development, social equity, and environmental sustainability. Now, Mahi Hudud, when we are talking about water law, what does water law cover? And what does it not cover? What are the limits to water law? So number one, water law deals with water rights and access. So that is the one area. When you're talking of scope, we are talking of an area, the coverage. So number one, water rights and access. It determines who can use water. So it is clearly written, if it is in a constitution or in a law or the doctrines of any country. So who can use water? So it determines the individuals who can use it, the communities, the industries, and the government. So may follow different doctrines. So when you're talking about water access, we shall talk about this in detail. So number one, we have the riparian rights, as we shall see later in detail. We have the prior appropriation rights. Then we have the public trust doctrine. So number one, water law deals with what? Water rights and access. Number two, allocation between users. So it establishes a system for distributing scarce water resources. Remember, we don't have enough water. We always say that the demand is high than the supply. So the water law, the law decides, it balances competing sectors. So agriculture, which is often the largest user, how much are they going to get? The domestic consumption for washing, cleaning, industrial use, and the environmental flows. Then there are also some tools they use. We shall talk about these tools. It's coming. So they can use license, permits, quotas, pricing. So all these mechanisms are used to ensure that water is effectively allocated to all the sectors. So we shall talk about the tools later as we move on. Now, number 3, water law also regulates, water laws also deals with pollution control. So regulates water quality standards. If you go to any country, we have the water law. The water law determines the quality of water. So number 1, it controls industrial discharge. We have some industries, they normally release water. They normally release polluted water to the rivers and oceans. So you'll find that in most of the countries, there are regulation for that. If you release, those water that are polluted in the water sources, you can be charged in a court of law. Agricultural runoff. Sometimes you find that it rains and some of the agricultural runoff, the fertilizers, the insecticides that are being used, they are carried to the water and it pollutes and contaminates the water. So water law determines all those things. Urban wastewater. In the towns, people are using water. They're using water to wash, and sometimes they pour this water in the water sources. So also, there are laws to ensure that people in town, they don't pollute the water sources. So, and the government can use what? It can enforce compliance through permits. That is why in many countries, the government will give you a permit. If you pollute, they'll cancel your permit or they'll not give you the permit. Penalties. Sometimes you can be given monetary penalties like dollars, thousands of dollars, or even millions for the big companies. Monitoring system. Governments, they also have monitoring system. And they normally have officers, supervisors, who always walk around to see the quality of the water. Now, another thing, the scope of water law is environmental protection. So, in this, we have protect aquatic ecosystem, wetlands, and biodiversity. So basically, when you are talking about aquatic is related to water. We have some animals and some plants that live inside the water. So it is the responsibility of water law to ensure that the fish, the shark, they don't die because of water pollution. We also have the wetlands and the biodiversity. Then ensures the minimum ecological flows in rivers. So you have these rivers, and the rivers, they have a minimum capacity in liters. So the government or the water law always ensure that capacity, the minimum is always there. The minimum capacity of water flows in the oceans, the rivers, ila ghairi dhalik. Then it integrates environmental principles such as sustainability, precautionary approach. When you are talking about precautionary approach, you are talking about a proactive approach. Precautionary is what they are normally say, al-waqaya khairun min al-ilaj. So the water law always comes with policies. We need to solve the problem before the problem actually happens. We should not be reactive. We should be proactive. And ecosystem-based management. Ecosystem management basically means protecting lives, living things. When you're talking about ecosystem, we're talking about living things, both in water and outside. Then lastly, water law also deals with dispute resolution. So it provides mechanism to resolve conflicts between, number 1, users. In many countries, you normally have conflicts between farmers and industries. So if there is any problem between them, then the law come up. The law has to deal with it. Then sometimes we normally have regions that are upstream and there are regions that are in the downstream. Their water supplies come from the waterfalls. The downstream, it basically means that the water is just from the rivers, and from the oceans. But the upstream is the water flows. So sometimes there can be a conflict between those who use the water flows and those who use the downstream. Then states, transboundary waters. Sometimes there can be a problem. There are countries that, for example, the River Nile, the case of Egypt, Sudan, and what? The Egypt, Sudan, and Ethiopia, they use the River Nile, So if there is a conflict, sometimes the water law can help us to solve the problem. So transboundary waters basically means that we have 3 or 4 or sometimes even more than that. They are sharing the same water source. So and there are a lot of mechanisms that can be used to do what? For the dispute resolution, as we shall see later also. So sometimes it can be taken to the court of law. Sometimes there can be arbitration. When you're talking about arbitration, like negotiation, all the parties are brought together, they sit and they agree. So it can be a win-win. Then sometimes there are administrative tribunals. When you're talking of tribunals, these are like committees that are formed. So if there is any problem, they're forwarded to these committees or the tribunals. So the tribunals, they are basically recognized by the constitution. They have powers to listen to cases and also determine what is going to happen. Then lastly, we have the community-based conflict resolution. So these are the informal. Remember in our last lesson, we talked about the formal, institution and the informal institution. So we have the community-based conflict resolution, like the council of elders, the clan leaders. So sometimes if there is a problem in a region, they are the ones who determine and they help to solve the problems. Now on to the next part of our lesson. And here we are talking about water sources. Maswadir al-Qanun. So sources of water law, just like we have sources of Islamic law. So for example, when you're talking about Islamic law, what are the sources of Islamic law? Number 1, Quran. Number 2, Sunnah. Number 3, Ijma. Number 4, Qiyas. So those are the sources of Islamic Sharia, Islamic law. The same thing applies to water law. There are sources. When you're talking about sources, where do we derive the principles, the rules that determine the water laws in a country? So number 1, water law is derived from multiple legal sources. There are multiple legal sources, often overlapping. Overlapping means they are hierarchical in nature. So number 1, in many countries, we have the national constitution. Every country has a constitution. So the water law, that is one source of water law. So the national constitution of every country may recognize water as a public resource. In all the constitution in the countries, they tell you that water is a public resource. Everybody has the right to get and use water. Number 2, in most of the constitution, they'll determine and tell us that right to water as a fundamental human right. All the constitution, there are 3 or 4 basic fundamental rights. Number 1, we have the right to water, we have the right to health, and we have the right to education, and we have the right to good health. Those are the 4 fundamental rights in any constitution in the world. So this provides the highest legal authority in any country. This is the highest legal authority guiding all water governance. It's just like in Islamic Sharia, the Quran is the highest legal authority. So when you're dealing with matters related to water law, the Constitution is at the apex. Then number 2, we have legislation. legislation. These are the water acts. And these are core statutory law regulating water use and management. They are statutory in nature, as we shall see later. And these statutory laws, they are established, they are enacted by the parliament. So parliament in their sittings, if there is any problem, if there is any regulation, remember, parliament is the legislature. It legislates the law, you know. So here you will have institutional roles, licensing system, enforcement mechanism. So all of these are determined. They are acts, you know. Then we have regulations. Regulation, these are detailed rules issued by government agencies. So legislation is by the MPs, the parliament. Regulation, these are rules issued by government agencies. In any country, we have a lot of agencies. So we have an agency that deals with water, the water board, for example, the water board authority. Sometimes you can have the quality assurance board, you know. So these, they specify the technical standards that are required, procedures for permits. For example, if you want a permit, what are the procedures? Monitoring requirements. These are issues related to supervisions. So those are. Then number 4, we have the customary. So these are the traditional norms governing water use at community level. So particularly important in rural and pastoral societies. It is important in the Alcaria and pastoral. Pastoral means the communities that keep camels, you know, the communities that keep goats, the community, the pastoralists, like the Somali. So in fact, you find that in the Somali communities, customary law is even. People normally actually abide to and follow the customary law more than the constitution. For example, the clans, the clan elders, sometimes they even have the power, more power than the government, than the constitution. People listen to them more than they listen to the government. You know, so this one's often based on collective ownership, shared access, indigenous knowledge system. Now, then lastly, the last source of water law is international agreement. These international agreements, they govern shared transboundary water resources. So sometimes, of course, if you are a student of law, we normally have the national law and you have the international law. So the national law is anything, for example, in Somali, anything that happens inside Somali, it is the national law that applies. But if something, for example, if a Somali person is arrested in is arrested in Kenya, or if a Somali is arrested in UK or in another country, what is going to happen in this case? We are going to apply the international law. So you cannot apply Somali law in Kenya, you know? So you cannot apply Somali law in America if somebody is a Somali is maybe arrested in America. So this is what is called international law. That is why you have the United Nations, you have the International Court of Justice. So all the cases that are between between another country, a sovereign state, and another sovereign state, they are forwarded to the international world. They are forwarded to the International Court of Justice. Now, what are the key principles of water law? Number 1, water law, they have to ensure that there is equity and fairness. That is, water should be distributed fairly among users. Number 2, sustainability. Water use must not exceed natural replenishment rates. So sustainability means that we should not overuse the water. That is, the demand should not be more than the supply. We should not overuse our rivers. such that the rivers cannot even actually produce water. That is the meaning of natural replacement rate. So we should always ensure that we don't overuse the water. So there should be no israf. Then number 3, public trust doctrine. Water is often treated as a public good, not purely private property. So this water is normally treated as a public good. It's a human right. So not purely private property. In some countries, they treat water as private property. Like they sell water. If you cannot afford masalam, that's your problem. So, and this is what happens in many capitalist system form of governments, you know. Then integrated water resources management, as we saw in our last lesson. So we should promote a coordinated management of water. We have the water, the land, and related resources. We should have an integrated system to manage the three. Then the precautionary principle, that is prevent harm, even when scientific certainty is incomplete. So when we always have to take precaution, al-waqaya. Then number 6, polluter pays principle. Those who cause pollution must bear the cost of managing it. So polluter pays. If this company pollutes the water, then they have to pay. They have to be charged. There should be a penalty for them. Then participation and inclusiveness. We need to include all the stakeholders. All the users should be involved in decision making. Now, on to the next part of our lesson. Remember, we've been talking about water law and rights. Now, what are those rights? What are water rights? So when we are talking about water rights are what? Water rights are legally recognized entitlement that allow individuals, communities, or institutions to use water from a specific source for defined purposes under specified conditions. So the Constitution, the law, provides people with rights to use the water. So it allows individuals, communities, or institutions to use water from a specific source. For example, if you are having a river as a source, the water law will determine, or the water rights is all about who has the right to use this river. For what purposes should they use the water in the river? And under what specified condition? So more broadly, water rights determine who can access the water. Number 2, how much. Then number 3, when. And number 4, for what use. So these 4 things are very important. So who can use? So if somebody comes who is not supposed to use the water, he will be arrested. How much? If you are using more than the prescribed amount, you will be arrested. When? For example, you are not supposed to use the water from 8 o'clock. You should not use water from that time. Then for what use? If it is for agriculture, it has to be for agriculture. So if they find you using it for industries or any other thing contrary to the law, you'll be arrested. Number 2, do not always imply ownership of water itself, but rather the right to use it. So the water right basically means it does not imply ownership. Like, this is my water, Muhammad. This is my water, Muhammad. It is written Muhammad. No. But the right, you have the right to use it. But it does not mean it is your water, that we are going to write the name there. No. Number 3, they are typically conditional, meaning they can be limited, regulated, or revoked by the state. So the water right, it is not like a permanent thing. No. The water law, the water right, it is not absolute. No. Water law basically means it is limited. Every right is limited. If you misuse the right, we are going to take it from you. So that is the meaning of conditional. So meaning they can be limited. We can tell you, no, Khalas, you've been doing a lot of israf. Please, you're not going to use this water. You've been using it for what? At the wrong time. No, now we are not going to allow you to use it. So it is conditional. We'll only give you this right with this condition. Then they are central to managing scarcity, competition, and sustainability. These water rights are always there to manage scarcity because water is not enough. So everybody has a right to use this scarce resource. And also competition, because there are some people, they always want to monopolize, those who have money. So if they monopolize, it means other people might not have the right. Now, this is what I was telling you before. The major water rights system. This is very important. Every country, they normally follow this water rights system. So different legal traditions have developed distinct systems for allocating water. So how do we allocate water? How are you entitled to the use of water? So there are three systems. The first one is riparian right system. Number two, prior appropriation system. Then lastly is a hybrid system. Hybrid means it's a mushakal, right? Now let us see one after the other. So let us start with the riparian right system. What is the meaning of the riparian? So the riparian system, the riparian right system allocates water rights to landowners whose property is adjacent to or riparian to a water body, such as a river, lake, or stream. So the riparian, this happens in many countries. The right to use the water is given to those people who own the land near the river. So if Mohammed, you are having your plot and the plot is near the river, you are the one, you have the right to use what? To use that river because you are close to the river. So that is the meaning. That is in short, that is in brief, the use of what? Riparian. So the riparian rights system allocates water rights to landowners whose property is adjacent to. Adjacent to means near, karib, near to, or riparian. Riparian means karib, to a water body. So the key features, the land basement entitlement. Only those who own land bordering water sources have rights. Only those who their land is bordering the water, they're the ones who have the right. Number two, the reasonable use doctrine. Water use must be fair and not excessive. Yes, your land is near the water, but you should use it. You should not do israf. Must not unreasonably interfere with other riparian users. So your right as Mohammed should not interfere with the other people who have the right. You have your land here, another person have their land, another person have their land. They have the right to use the water. So you are right, you should not interfere with their rights. Shared access. All riparian landowners have equal rights, regardless of who started using water first. So all of them, Mohammed, Khadija, all of them, they have the equal rights, so long as they're the landowners. Then the natural flow principle. Water should not be significantly altered in quantity or quality. So the landowners should not alter the quantity or quality. For example, you as Mohammed, you decide to divert the water to your land. You build a dam. So it means Khadija is not going to get enough water. Why? Because you, Mohammed, you diverted the water to another area. So it is affecting the quantity or quality. Maybe you are polluting the water. So when you're polluting the water, all the other landowners, it's going to affect them. Number two, so this one, it has its advantages and disadvantages. So advantages, it promotes equity among neighboring users. Everybody at least can get water. Encourages cooperative use of shared resources. Ta'awun. Number 3, works well in water abundant regions. This system, it only works well in areas that there is enough water. Like in Somali, this system cannot work. But this system can work in areas where there is enough water. Then what are the disadvantages of this system, the limitations? Ambiguity of reasonable use leads to dispute. So reasonable use, how can you define reasonable use? Israf, well, how can you define israf when somebody is using how much of water? It is difficult to say if you are using the amount. It is difficult to determine the israf element of the usage. Number 2, not suitable in arid or semi-arid regions. It's not suitable in Somali or Djibouti. You cannot use this system in Djibouti or Somali. Exclude non-land owners, which can reinforce inequality. So it excludes those people who don't have land. So if you don't have land in those areas, you cannot own it. So it can lead to inequality. Only those people with the land can use it. Then difficult to manage under high population pressure and competing demands. In area where the population is very high and where there are competing demand, agriculture sector, industry, domestic, there are a lot of competing demands. It is very difficult for this system. Now, another system is, the second system is the prior appropriation system. Prior appropriation system. So this system is very interesting. The prior appropriation system is based on the principle of first in time, first in right. First in time, first in right. Meaning that the first person to use water beneficially acquires a legal right to continue using it with priority over later users. So this, for example, if you are in an area, if you are the first one to come in that area, you are going to be number 1 in the list. You have the right. Number 2, if you come in position 2, you are second. If you come in, so the first person has the first priority. So what are the key features of this system? Number 1, it is time-based priority. Earlier users have senior rights, while late users have junior rights. So the first people to come in that area, near the water source, they are seniors. Those who have lived in those areas for many years. But if you come on a later stage, you'll be a junior. You'll have junior rights. Number 2, not tied to land ownership. Water can be used away from the source. So this one is not like the first one. So it's not related to what? It's not related to land ownership. Then beneficial use requirement. Water must be used productively. Then lastly, priority during scarcity. Senior users are served first, junior users may receive nothing. So if the water is not enough, we are going to start with those ones who came first. Then later, those who came late. And this will lead to inequality. So we'll continue after the break. We only have a few seconds remaining. Now, but before the break, let us look at the advantages and limitation of the prior. So it has advantages, it has disadvantages. We have only how many seconds? 20 seconds. So what are the advantages? Number 1, so it provides clear and predictable allocation rules. The rules are very clear. Senior first, junior second. Suitable for water scarce environment. So this system is very suitable to be used, for example, in Somalia or Djibouti or those areas that don't have enough water. Because even if it is not tied to a landowner, anybody can use the water.